Good morning, friends. Today we are going to deal with an area which is both a part of the administrative law, it's important in administrative law, as well as it is very much important in the constitutional law. And the topic is Article 12 of the Indian Constitution, or Amenability to Writ Jurisdiction. Amenability to Writ Jurisdiction. What does it mean? So as I told you earlier, it is important both under the constitutional law as Article 12 of the Constitution and in the administrative law as a part of amenability to writ jurisdiction. Amenability to writ jurisdiction means who can file a writ petition and against whom you can file a writ petition. To be very appropriate, against whom you can file a writ petition. That is called amenability to writ jurisdiction. As we are aware, a writ jurisdiction is an extraordinary jurisdiction. Usually, if you want to file a case, we will go to the lower court and you file a case. Suppose there is a property dispute or a small civil suit. You have to go to the lowest available court. Maybe that is the municipal court, or you go to the subordinate judges or assistant district court according to the jurisdiction. So that is the usual process, and after that you can go to the higher court in appeal to the district court or the high court, then again in appeal to the Supreme Court, but you start with the lowest court. And generally a person cannot directly file a case to the High Court or the Supreme Court. That is the ordinary principle. Now, there are certain instances where a person is able to file a writ petition or a case directly to the Supreme Court or the High Court. And the classic example for this is the writ petitions. So, when you are filing a writ petition, you are directly filing a case either to the High Court under Article 226 of the Constitution or to the Supreme Court under Article 32 of the Constitution. You can file a writ petition for various reasons, but one primary aspect for which you file a writ petition is for the violation of the fundamental rights. So when your fundamental rights are violated, the importance of fundamental rights is fundamental rights, unlike other rights, are certain rights which are guaranteed to every Indian citizen under the Part 3 of the Constitution. This is a right which is directly given by the Constitution to the citizen or the individual, and there is no role of legislature in it, as it is confirmed by the Constitution makers through the Constitution, by the people who are the sovereign of this country, directly to the people. It is investing the power with a citizen to directly fight the state even using this writ petition. I mean, that is the fundamental rights are rights which are conferred on a citizen directly by the Constitution. And if these fundamental rights are violated by anyone, including the state, and I think mainly it is by the state, you have to understand in detail that is, when your fundamental rights are violated by private person, your remedy is different. But when your fundamental rights which are directly given by the Constitution is violated by the state, the small citizen, a puny individual citizen, can fight the might of the state by filing a writ petition either to the Supreme Court or the High Court. So this is the importance of the fundamental rights. So having known the importance of fundamental rights, that is, if your fundamental right are violated, you can directly file a case to the Supreme Court or the High Court challenging the might of the state. Then we have to understand what is a state. That is you file a petition to the Supreme Court or High Court against a state for violation of fundamental right. And one primary requisite for filing a writ petition is that your fundamental right is violated by the state. Is it not? Now the question is, what is a state for the purpose of Constitution? See, a state is defined in Article 12 of the Constitution. A state is defined in Article 12 of the Constitution. And if a body coming within the purview of Article 12 of the Constitution, or a body which can be termed a state under Article 12 of the Constitution, violates your fundamental right, you directly file the case to the Supreme Court or High Court. Now here in this class, we are going to find out what is a state under Article 12 of the Constitution. See, the importance of this article is that this is the first article in the Fundamental Rights chapter, that is the Part 3 of the Indian Constitution. Now, let's directly go to the, the definition. I am not going for a in verbatim, or I am not going for a exact wordings in the article. I will just go to what is the content of Article 12. See, Article 12 of the Indian Constitution says that a state means, one, the parliament and government of the center, or legislature and government of the center, which means the Parliament of India and the government. Secondly, the legislatures of the state and the state governments. So that is very obvious. They are state. Parliament and the government of the center. That is the state. Secondly, the state legislatures. That is the legislative assemblies. And the state government. They are also state. No confusion. Thirdly, local authorities. Now, what exactly you mean by local authorities? Local authority means the municipalities, the corporations, and the bodies like that. That is also a state. And fourthly, the other authority. Other authority. So the definition goes like, state includes parliament and central government, state assemblies and the state government, local authority, and fourthly, other authority, O-T-H-E-R, other authority. Now the question is, what is other authority? Now, as the term other authority is not defined in the Constitution, the meaning of other authorities have been interpreted by the Supreme Courts, and different bodies have been brought within the purview of other authorities and brought within the purview of state by the apex court and the high courts. Now in this class, we will study one by one the case laws, because it's totally a development in the case law, because first three part needs no explanations, but the fourth word, other authorities, have to be interpreted, and along with interpretation, new bodies can be brought within the purview of state. And a body, if it is found to be a state, any action of that body violating your fundamental right can be challenged by an individual before the High Court or the Supreme Court. I am a little fast today because I see that most of my videos cannot be finished within a short time. So I'm just adding momentum to how I present my topic. Now let's directly go to the cases. The first case in this category is University of Madras versus Shanta Bai. University of Madras versus Shanda Bai. Very early case, the 50s. In this case, the question before the court was whether University of Madras comes within the term other authority under Article 12 of the Constitution. If it comes within other authority, it becomes a state and you can directly file a case against the university to the High Court or the Supreme Court by a writ petition. Now in this case, the apex court went for an interpretation which is commonly called the justum generis rule of interpretation. Justum generis rule of interpretation means of the same kind. That is, it means that when you group things, it should belong to one particular category. That is, if you are grouping vegetables, you can't bring some other things like what you call fruits in it. If you are grouping fruits like apple, oranges, apricots, etc., you cannot bring green vegetables in that category because things should be grouped together of a uniform or somewhat similar group. Similar things should be included in a group. This type of an interpretation is called the principle of justum generis. It has to be interpreted. This principle of interpretation, it requires a lot of time for further clarification, which I am not going, and it's not relevant as far as this case is considered. But whatever it is, the court, using the justum generis principle of interpretation, held that the University of Madras or universities will not come within the purview of other authority under Article 12, and hence they are not state. The court adopted the standard that, see, when you look into the Article 12, we see that Parliament and government of the state legislative assembly and the state government, local authorities. Here, all these bodies are to a certain extent included, or members which are elected to a certain extent. And further, they have certain, they are a part of the sovereign and they have sovereign functions. But the university, the problem is that the university, even though it is created by a statute or it is a body functioning under the government, is of a different nature. Not like elected bodies or bodies having sovereign functions. So it cannot be grouped together. That was the concept of the judges of that time, and they held that university can never be considered to be state under Article 12 of the Constitution. So that was the first case in this category. Now, after Shanda Bai case comes the second case. The second case is Rajasthan State Electricity Board versus Mohanlal. Second one. Rajasthan State Electricity Board versus Mohanlal. In this particular case, the question was whether the electricity board, just like you have the Kerala State Electricity Board earlier, the Rajasthan State Electricity Board, whether it comes within the purview of state or whether it comes within the purview of other authorities under Article 12, and if it comes under the purview of other authority, obviously it will come within the purview of state. That was the question before the court. In this case, the court went for a broader interpretation. That is how the court do. Court can interpret laws. Anything can be interpreted anyway by the court. It should be reasonable and rational. It should not be unreasonable. That is different. But the court has a freedom to give a different interpretation. I know in 1 year I taught my students that in India you have a right to commit suicide because the court then, in a case called Ratna Nagabhushanam, held that right to life under Article 21 includes right to die. However, in next year I taught my students there is no right to die because that decision was overruled by the court in Gyan Kaur. So it so happens that court can give different interpretations. And in the case of Rajasthan State Electricity Board versus Mohanlal, the court came with a broader interpretation, and the court held that earlier it was the justum generis rule which was applied. Here a broader interpretation was used, and the court held that if a body is a statutory body, it is a state. If a body is a statutory body, it comes within the purview of other authority under Article 12, and hence it is a state. Now the question is, what is a statutory body? No, statute means it is a law enacted by the Parliament. If you take Indian Contract Act, Sale of Goods Act, Transfer of Property Act, if you have the name Act, obviously it is a law created by the legislature. And law created by the legislature is called either a act or a statute. And therefore, any statutory body means if a body is created by a statute, that is a law enacted by the Parliament or the State Legislative Assembly, then that is a other authority within the purview of Article 12 and hence a state. So a broader aspect was taken by the court. And the court, using that interpretation, held that obviously Rajasthan State Electricity Board, as it is created by a statute, the Rajasthan State Electricity Board Act, just like Kerala State Electricity Board Act, it is a statutory body and it comes within the purview of state. It's broadened. The court have given more broader interpretation. Usually happens. Now we come to the third case, and the third case is Sukhdev versus Bhagat Ram. Sukhdev versus Bhagat Ram. In this case, the question of status of so many bodies, mainly the ONGC, Oil and Natural Gas Commission, and so many other bodies was an issue. Here, I think it was K.K. Matthew, a very celebrated judge, who did one of the judges who decided the case. K.K. Matthew's son, Mr. Joseph, I think he is presently the judge of the Supreme Court. And K.K. Matthew is considered to be a judge who made very rational judgments. And many of them shows us judicial and juristic mind when he decided the cases. So he was there, honorable judge was there in the bench, and in this decision they came with a broader concept. The broader concept was, now the question we are discussing is, what will come within the purview of other authority under Article 12 of the Constitution? Here the court held that if a body is an agency or instrumentality of the state, if a body is an agency or an instrumentality of the state, then it will come within the purview of other authority and hence it will be a state. So the decision gave a much broader interpretation. That is, more bodies can be brought within the purview of Article 12 of the Constitution, or amenability to writ jurisdiction. They said that an instrumentality or agency, that is, if a body is like an agent to the government, or it is an instrument of the government in the sense that it is the state or the government which manages the body, then it will come within the purview of the state. So a slightly more interpretation was given in the case of Suffragette versus Bagaitra. That is the third case. All these cases you can remember, because if you give the chronological order of the evolution of this particular rule, you get maximum marks. Remember 4-5 cases. Now, the case which followed Suffragette versus Bagaitra was R.D. Shetty versus Airport Authority, where the issue was whether the airport authority comes within the purview of the state. Now, here also the judges reiterated what was stated in the Suffragette case. That is, that line of argument was adopted by the court in this case also. That is, if a body is an agency or instrumentality of the government, obviously it will come within the purview of state. That was the argument which was adopted by the court. But here, the court also laid down, in this case also the case which followed, Som Prakash Rekhi case, another case which followed us. In both this case, the court held that a body which is an instrumentality or agency of the government, obviously it will come within the purview of Article 12, other authority, and obviously it is a state. The court also laid down certain tests to determine whether a body is an agency or instrumentality of the government. Certain tests were laid down so that we can distinguish whether a body is a state. What were the tests? Tests were like this: whether the government has control over the body, whether the main funding of the body is given by the government, whether the government has the power to appoint the persons who are in driving seat of that body, or they have the power to dismiss those persons. So such riders were added by the court. Tests were given whether to determine a body is an agency or instrumentality of the government. And further, the court held that a body to be considered as a, what do you call, agency or instrumentality of the government, there should be a deep and pervasive control. That is the word which is used. Deep, D-E-P, and pervasive, P-E-R-V-A-S-I-V-E, pervasive control. The body, over the body, the state should have a deep and pervasive control. If such a deep and pervasive control is there, obviously it will come within the purview of the state. So here ends one line of cases which have given a broader interpretation to the concept of other authority, and brought many more bodies within the concept of states. Now, there are also decisions which are going against this flow, and also decisions which are going on the lines of this flow, on the lines of this evolution, means they are giving broader and broader interpretation, bringing more and more bodies within the purview of state, so that you can file more and more cases, writ petitions against such bodies. In a case called Suffragette Tiwari versus Union of India, the Supreme Court held that CSIR, Council of Scientific Research, this body, as it is a body created and a society, as it is a body created as a society, and further dealing in educational and research and all these things, it will not come within the purview of a state. That was the angle which was adopted by the court. And again, in another case, the court had held that NCRT will not come within the purview of the state, NCRT. So these are decisions which go against the current. But it has to be noted that in an earlier case called Ajay Hasia versus Khalid Mujib, where the question before the court was whether REC Kashmir, Regional Engineering College Kashmir, will come within the purview of state under Article 12. That was the issue. There the REC Kashmir was created under the Societies Registration Act. But it was administered and controlled both by the central government and the government of Kashmir. There were controls over it. So even though it was a society, as the control was with the government and there was deep and pervasive control, the court held that obviously it will come within the term other authorities and therefore it is a state. However, in NCRT, Suffragette Tiwari and CSIR cases, the court adopted a different stand. That is left to the government. So, left to the courts. Which interpretation has to be given, that is left to the judge. Now, in the current years, the usual trend of the court is that the court is interpreting the concepts of state in a very broad way. More bodies are brought within the purview of Article 12. More bodies are brought within the purview of other authorities under Article 12. This is the line which is adopted by the court, and that is good. So if you bring a body under the purview of Article 20, obviously if you have some grievance, you can file a case against them by a writ petition directly to the High Court or the Supreme Court. That's good. That is a committed decisions. So this is how the term Article 12 is being interpreted. It's evolving. Now in this aspect, there is another small area which have some interest. It's maybe interesting for you. Now the question is whether judiciary comes within the purview of state under Article 12. It has to be treated at a different level. It's obviously state includes both the legislature, executive and the judiciary, and in that respect, judiciary is state. Now here the question is not that. Here the question is, when a judge decides a case, the High Court or the Supreme Court decides a case, can you file a case against that decision under Article 32 or 226 claiming that this decision is violating my fundamental right? That is it. That is, from a decision of the High Court, you can go to Supreme Court in appeal. From the decision of a lower court also, you can go to Supreme Court or High Court in appeal. It is not that. But there are statutory requirements required for you to file a case in the High Court or Supreme Court from a lower court decision. Here it's not like that. A High Court or a Supreme Court decision, instead of you going for the statutory provisions of appeal, you say that the decision of the High Court or the Supreme Court is violating my fundamental right, and therefore you are filing a writ petition against that decision under Article 32 or 226 of the Constitution. Both are different. If you have to go through that in the books and you can become more clear. In cases, it was categorically held that when a court is deciding a case, judicially, that is, a list is before them. A list means a dispute is before them. And they are applying the judicial mind and deciding the case. And if the court is deciding the list before it, applying the judicial mind, that is, judicial mind is being applied. A judicial decision has been taken by the court. Against that decision, you cannot file a writ petition claiming that this is a decision by the state and this decision violates my fundamental right. So that is it. So, in the process of judicial determination, a decision is made, and decision you consider to be a violation of your fundamental right, you cannot file a writ petition to the High Court and the Supreme Court. That is the general approach of the court. It was decided in the Naresh, one case of Naresh, and also another case of Ruba Hora. Naresh was a state and Rupa Hora case. However, there is another aspect to it. In cases like R.S. Naik was A.R. Andule, cases like this. You see, judiciary have several functions. One function is that the main function and the major portion of their work is with regard to deciding cases before it. That is judicial job. But the apex court and the high court, they have also other functions like administrative functions, lawmaking functions. They create some rules for governing the activities inside the court and all. They have administrative functions. So if the judiciary in the course of administrative or legislative or rule-making functions make certain activities, for example, the High Court is taking action against an employee, you consider in the administrative capacity. So if the function is like that, other than the judicial function, then it is also subject to Article 12 of the Constitution, and a person is entitled to file a writ petition. But generally, when deciding a case, that is acting judicially, there are different opinions. In very rare cases, the court have come to the conclusions that usually what is judicial, what is administrative, it getting obliterated. But the general principle is that when it is applying its mind judicially and in the process of a judicial determination, that cannot be challenged by a writ petition under Article 32 or 226 of the Constitution. So I made it very fast so that we can finish it off in time. I hope you have understand. And the concept is amenability to writ jurisdiction is the topic which is being asked in administrative law. Secondly, Article 12 of the Constitution will be the state under Article 12 of the Constitution will be the question which will be asked in constitutional law. The answers are same and the area is also same. And here the question is, you can file a writ petition provided the body which violates your fundamental right is a state. In Article 12 of the Constitution, the state is defined. It is defined as central legislature, state legislature, local authorities and other authority. The first three is clear. The question is, what is other authority? If a body can be produced in the category of other authority, then obviously it would be a state and you can file a case against it. The cases have decided that bodies like electricity board, universities, even though in Chadabai it was earlier and it was not state, later it was well determined that university comes within the purview of state. And so many bodies, ONGC, Airport Authority, and in one case Burma Shell, even a commercial organization, all these bodies come within the purview of state. So, hope you have understood. Go through your textbooks. Good day. Thank you.